Well, thank everybody for coming up. We're going to get underway here. This is actually the first of a series of lunch and learns that the Life Sciences and Technology Group is going to offer throughout the rest of the fall and into the winter. This one on cloud computing. In a couple of weeks, we'll be doing another installment on open source and sort of hot topics and emerging trends there. Followed up in late November with another installment on the American Invents Act and the patent reform, and then we'll be doing another one early January on government sources of fund and incentives in order to develop and commercialize technology. So I hope that into this one you'll join us for some of the others, and then probably into the spring you'll see more in your inbox of some other offerings that we'll have. So again, thanks for coming out. My name is James MacDonald. I am a business finance attorney here at Ballard, and I focus my practice primarily on technology-related issues, transfer of technology, whether through M&A, licensing, development, collaboration, strategic alliances, licensing, and here presenting with Carl Roberts, who's in the litigation practice. I'll let him introduce himself, and we will promptly begin. Thanks once again.
Thank you, Jay. As you said, my name is Carl Roberts. I'm a partner in the litigation department. My principal substantive areas are construction and real estate litigation. I chair the firm's construction litigation group, and software and technology litigation. I've been involved in one aspect or another of technology in connection with the practice of law, then as a substantive pursuit area since the early 1980s. And I've also been more recently dealing with technology as it's harnessed in the construction industry through things like building information modeling and the like. Through the litigation side, I've dealt with discovery, and that moved into electronic discovery, and have been active in speaking and writing about that for more years than I want to count. And as cloud computing emerged as a way of providing computer resources, I've followed that as well. And what we'd like to do today is give you some sense of what's out there. I think John and I both find it very exciting. There are all sorts of interesting possibilities. It really is an agent of change throughout the way business is done. One housekeeping matter are evaluation forms on the tables at the end of the seminar. We would appreciate it if you would fill it out and leave them to be picked up. And without further ado, Jay?
And we'll hold questions till the end. We'll leave some time at the end to take any questions that you have.
But really, really, really vigorously waved hand might get our attention in the middle.
Or throw something. Cloud computing, I think everybody has a different opinion on what cloud computing is exactly. We wanted to sort of dispel some of the mystery around it. It's pretty ironic that the geniuses that invented the term picked for a remote network solution, something that's open, sort of invisible there, and really you can't grab foggy to be precise as the term to describe technology. And this is a quote that the CEO of Oracle provided a couple of years ago now when he was asked to define cloud computing, and we happen to agree with him. Cloud computing really is nothing more than an extension of outsourcing arrangements and remotely hosted solutions dealing with technology that we've all been dealing with for a long time. Just a new term that probably has generated revenue for somebody.
The suggestion I've heard, it comes from data mapping, is that the cloud may have been picked as a term because whenever a map of the network structure and the arrangements is made up, the way that the designers and drawers of these maps work is to take everything out there and put the kind of cloud that you see on architectural drawings out there, so they don't have to put any detail in it. One of the things we're going to try to do it puts some detail in those clouds in the course of today's talk. The next slide shows you the more formalized definition that the National Institute of Standards and Technology has developed, and I think there's a couple of terms that are central to cloud computing and distinguish it from many other provisions of services. The first is the word on demand. This is not something where there are specific resources that are always there, but rather they are extensible, they're available when needed. Network access. It's not a desktop. This is something, as Jay said, that's out there. The pool. This is a shared tenant arrangement. One does not have an individual machine or set of resources for every individual in an enterprise. Rather, as it is needed, someone can sit down. It's much like a kiosk if you think of some of the network cafes or internet cafes that are available in this country and in Europe. Computing resources, because that's what we're talking about. But computing resources is a fairly broad term. It can mean anything from the very raw base levels of the virtual equivalent of drives and processors and network connections up through operating systems, up through specific software. Rapid provisioned and released. Instead of having to call up the IT desk and arrange to have additional memory or a larger hard drive brought to your desk, this happens to the user effectively automatically or behind the scenes. It's something handled by the host. There are a number of service models, and this level of technology becomes important as you start to think of issues for these kinds of services, many of the things that Jay will be talking about. So that's why we're going to go into a bit more of the depth at the very beginning. This is a chart that was prepared. We've borrowed it from, I believe it's MEMSET, and it depicts various aspects of what is in, if you want to pick a picture, very complex desktop computer. But now we're moving further back. So at this basic level, what is referred to as infrastructure as a service, the host is providing the bottom set. It is the mechanical and electrical components, the power supplies if you wish, networking connections, physical layers, the machinery, and a virtualization layer, something that breaks up what's in supercomputers into virtual units that can be worked. So if you want to imagine it's all in virtual space, it's as though you've got a whole series of PCs or laptops, but they're all a certain amount of memory, a certain amount of storage, a certain amount of processing power, each one sitting, if you wish, next to each other within the virtual space created by a much more powerful computer. The kind of cloud service one can contract for is platform as a service. One adds on to this, the host adds on the operating systems and infrastructure, connections and linkages. We are still, at this point, agnostic as to the software. So with infrastructure, somebody can pick the equivalent of a Microsoft operating system, Linux operating system, some other kind of operating system, and the user who's contracted for infrastructure as a service can install those operating systems and operate them. When you get the platform as a service component, now you effectively have a built-out machine in a virtual sense, but it has no software on it. You can pick the software you can want to operate. You can develop specialty software that's purposes. The power on these virtual machines is quite high, so they're well suited to dealing with huge quantities of data, lots of simultaneous users shifting in and out, and various specialty kinds of processes. For example, various kinds of design-related things where you need an enormous amount of horsepower to render images in multi-dimensional formats. The final setup is software as a service, and that is when particular applications are selected by the host. One contracts to use the host's software in a shared manner. And so this is the third layer. You build these different vendors may be providing different layers. So, for example, Amazon or Microsoft might be providing an infrastructure layer to a company that has then outfitted it as a platform layer. You, end user, might simply be going for software as a service, but if you read through the terms of use in the contract, you'll find that your vendor has actually arranged with other providers for the platform and the infrastructure. So you can end up with a fairly complex structure of contractual arrangements, many of which are invisible unless you start going deep into the fine print, sometimes not even in the fine print. Now, there are also a number of different ways to render this. We'll work through a couple of these because, again, they assess some of the risks, some of the benefits, and the costs that one has to keep in mind. The simplest one would be a private cloud, where you have the service, so maybe a very high-powered server that is operating Citrix. Within that, it's configured as a series of different machines. It would be useful, for example, if there is a high per seat charge, very specialty software. Not many people within an organization are using it at the same time, but ultimately a lot of different members of the organization might need to use it. If it's installed on a Citrix server, to use one, or a VMware server, then you meter, say, a half a dozen instances of it. You may have 100, 200 people will come in, but they will, in effect, sit down at a virtual kiosk, use it for what you need to, and leave it. It becomes available for the next one. There's a boundary with a private cloud. This is possibly physical as well as electronic, but it makes it private. Those within the organization have access to it. People in the organization connect into it probably over an internal network, and an arrangement to become complete, to deal with remote users, there's a protected linkage which brings the remote user, who is a member of the organization, inside. Dave Ballard has self-up for many reasons. We use this kind of arrangement for some of our specialty softwares, where it can be reached from a desktop sitting within the firm or somebody outside who can link in through a series of passwords and identification modes, can then get to the software to do various kinds of activities. Next model is a community cloud. The example might be a corporation with several separate divisions in different business lines, but there are, and each division may have its own large computing resources and some specialty information or specialty applications. People in other parts of the company may need access to that. So you have, within any particular enterprise, you've got effectively your private cloud. You have users in the different organizations working through their network, have linkages among the various pieces of the organization so that someone in, say, the headquarters unit can reach out to applications that are only available in something that does some specialty aerospace work and has some particular design software that needs to be used or reviewed. Public cloud, which is what most people think of when they hear the term cloud, is with a provider that is independent, really, of the users and provides the cloud resources. These are supercomputer farms in specialty locations. The arrangements are that they can bring in and out real resources as they need to add or reduce their power. They borrow these from another cloud provider as well, and they will provide the services to their users. The people who are using the service are the public. There's no need for a relationship one to another. They come in over public networks. But you can also have an organization that enters into a contract for a quantum of services and makes that available in a managed way to the members within through their network. We have variants on this theme. For example, an outsourced private cloud. So you have members within the organization working through their network, linking through a protected manner to a cloud provider, which has established or created a boundary around a quantum of services. It might be at any level, infrastructure, platform, or software. The perimeter that is created is created most likely through software means, access through various kinds of passwords, encryption methods, and the like, although it is possible that there are individual machines that are dedicated to an organization. But there is the capability going beyond that if one needs additional resources. And so you have this cross where you have a private base within a much larger public space. This can be done for community with the various members of an enterprise. The different divisions may have a global contract with a cloud provider for the resources they need. Finally, you get into what is the real world from the user perspective, a combination of all of these. And the individual user may not know that. The organization, if it's not paying attention to how things are structured, may not know this. But a combination of on-site private clouds, community clouds, out private and community clouds, and public cloud services linked, at least in the real way, through protected connections that allow the user to have access to what they need.
So what those models demonstrate is that you have basically a new way, well, a remote way of providing solutions that offer a variety of benefits. And the rise in the popularity of cloud solutions is based on mainly these benefits, which is improved access when you need it, increased availability because the cloud is a 24/7 operation in most respects, and these benefits come with shorter or less costly capital commitments. In essence, what you're doing many times is you're converting capital expenses to operating expenses, where a company that would seek to update IT infrastructure would be looking at purchase of equipment and personnel resources, which are typically front-loaded expenses, and while they could be depreciated, the more even, predictable budget of an operating expense for subscription fees, which is primarily the means by which cloud providers charge, or resource fees based upon how much you use, is in many cases more attractive. This can result in reduced costs, but it doesn't always. While it be an accounting benefit, in the long run, it may be actually more than the initial CapEx spend, and get into some of the risks that excludes the cost of the risks, and we'll get into that. But cloud also offers a more efficient use of resources. In fact, now there's a movement underfoot to make cloud resources a green-friendly solution as well, because they can be located, they're location independent, and so you can locate a data farm in a place where power is cheaper, or there's more access to solar, or a cool environment where it's easier to keep the machines cooler. And so actually we've seen this being used as a marketing facet for reasons to choose cloud over an existing IT infrastructure. And scalability is probably one of the biggest advantages, because you can dial up or dial down the resources that you need very effectively. Enhanced computer power. Cloud providers are typically much better at staying abreast of technology developments than the individual consumers and businesses that are using them. And here we'll highlight some of the risks. We'll get into greater detail in a few minutes, but as you can imagine, if somebody else is taking care of your data and your infrastructure, you lose control, and your only basis to obtain or assert control is what's called the terms of service, or terms and conditions. And we'll get into later on the assurances that you will be able to maintain control, and the remedies that you'll get if the cloud provider loses control are very, very low level on the instances. For large commercial or government applications, there is increased ability to negotiate these terms, but still the loss of control is something that you have to factor in. Loss of confidentiality, cloud providers are bigger, in most cases, bigger targets, and they are focus of security breaches. They have more information, therefore they're rich targets for hackers, and we've all read this lately, and it's legion with the data breaches that cloud providers suffer. So data deletion, those are sort of related to those risks. If you have diligence the solution, it may well be that your data is located in places that would expose you to the laws of different jurisdictions. You have responsibilities to your clients, and in most cases, the legislation still remains that if you are the one taking the consumer data, you are primarily responsible to your consumers, and so that's not something that you can effectively outsource or allocate to the cloud provider. The other issues really highlight the compatibility concerns that not all cloud solutions will be as seamlessly compatible with customized solutions that you may be employing in your operations now. And the data ransom point is simply, another form of hacking that is emerging is that and other organizations are actually using the prospect of hacking in order to extort large sums out of global commercial companies that use cloud resources.
Another aspect of data ransom, which is if something happens to the provider, the fact that it's holding the only copy of an enterprise's data gives a certain amount of leverage for extracting some additional money out of that enterprise for return of the data in short order. So again, one has to set up the arrangements here. We've picked a number of examples. We keep updating this set of slides and then read through them because they're in your notes. I'll try and extract what are the patterns of these. Things one recognizes from some of these is that the security perimeters with cloud providers are largely software. Software can have bugs, it can break down, it can be penetrated. Furthermore, and it's better now than it was as the developers have worked on it, but because the virtual machines are in close proximity to one to another and sometimes will share space within the cores of the operating chips, there were data leakage issues in the early stages, similar to what forensic computer technicians would do when they tried to find the data that had been erased but not really deleted or overwritten from the hard drive. This was the virtual equivalent. Hackers have access. If it's a public cloud, a hacker can probably get into it without having to expose oneself. If it were a machine, a private system, then they need to be inside the perimeter or have a way of coming inside the perimeter. And the size makes these kinds of systems very exciting targets. In addition, provider staff can make errors. There are examples where the people hired by the provider didn't implement a change appropriately and exposed a great deal of information. Some of this information is protected personal information, which sets up a data breach consequence. It wasn't even recognized in one recent instance for almost a year, about 20,000 records involving diagnostic codes and the like from a hospital in California. Because of the extent of resources that are being made by cloud providers, you're often dealing with very large quantities. So if there is data breach, the consequences can be enormous. And then service interruptions. Even the most significant of the providers have, in the course of the last year or two, had instances where a power outage has taken out systems, a software glitch on an update completely destroyed Google Mail for a period of time. They actually had to do something I don't think cloud providers expect to have to do, which is go back to tape to restore the systems. So they were able to do that. Our friendly law enforcement agencies have themselves wreaked havoc in a few instances, because when they have descended on a cloud provider that is providing services to a criminal enterprise, their approach has been to pack up the server and carry it off. If that server is being shared with users who have nothing to do with the enterprise, they suddenly find that they may be interrupted. And if the cloud provider has arranged, there may be a backup to bin, but there have been instances where the users who were, or the using enterprises that were not part of the organization, have actually had to bring a injunctive suit against the FBI to try and get their data back online while the FBI is scrambling over the weekend to pour through the hard drive. What we thought to do next to further set this up before moving into the contractual aspects of this is give you a scenario, sort of a, it actually is a real-world scenario for something that might be presented for e-discovery. When one thinks of this from the perspective of litigation holds and e-discovery, this may be more of a nightmare scenario, but it is real. So your business we're dealing with has multiple divisions. They're in different business lines. So each one of them may have its own computing resources, its own people, its own needs, but they're part of a larger enterprise. Because of the capabilities that it provides, a program Salesforce, which is right now the lead contact manager available, is being used by salespeople in the many different divisions. They manage their proposals, their contacts, contact information, the like. And they also will transmit proposals and bulky documents because the mail server may have a limit of, say, 3 to 5 megabytes of data going out with any email message. You don't have that limitation with some of the cloud providers. Marketing, which from different divisions wants to do very advanced graphical and video development, is strapped for computing resources. No one wants to spend the tens of thousands or hundreds of thousands of dollars it will cost to put very large machines on individual desks. So they out through some of the providers that make these resources available at the most advanced stages. Employees are encouraged to blog about the company's activities and the things that they're marketing and selling, and they're using social media sites. The LinkedIn and Facebook are now being used a great deal for marketing. So a lot of the company's marketing information is up there. There are excellent collaborative development tools available through cloud providers. So when working with people in other divisions or within different parts of the company located physically remotely, or customers, proposals, documents of one sort or another are being done, again, through the cloud. And finally, employees are finding it easier to send material home to their home email because they can get at it and work outside, or remote traveling employees here and abroad are coming in through networks and using the various kinds of mail services are there. From the company's point of view, everything is clicking along fine. There's greater productivity from their employees than they've ever seen, and their capital outlays have gone down. If the company wasn't thinking very far ahead, or maybe part of the reason they've gone this way is they've dismissed a lot of the IT staff, since they're no longer maintaining large amounts of silicon and the like in specialty rooms. That's the litigation. Usually a step in litigation is to put a litigation hold in place. In order to do that, you have to find the data. Where is data? The data all over the place. It may be available only through individual employees with their own personal passwords. But if the employee is no longer in the employ, no one knows where to find it, no one knows the account name, no one knows the password. Collaborative systems, they often don't maintain a long historical record. Likewise, the various kinds of tools for providing websites and the like, if they're up there, may not maintain a great deal of historical record. So one starts with a terrific problem of trying to track down the data. On-cloud problem right now, where the entire division, including the hardware and the personnel and the software, was sold to another company. 6 years later, a copyright issue arose, and we are scrambling to find the data because no one who knows what happened, where it is. The physical situation, in the cloud, you're very susceptible to that. The good of this is if you can locate the information, even if it's in the cloud, tools are being developed to allow researching, searching, locating, and processing data in the cloud. A noted writer and consultant on e-discovery, Craig Ball, has observed that to make a duplicate copy of everything to preserve it actually may not be necessary in a cloud environment because one can, if the tools are there, set tensions with hard stops, things aren't deleted, the cloud provider is handling the backup as long as you have access. Going to our present situation, what typically happens is, having found cloud data, we'll ask the provider to make a copy and send it back. Well, that's not usually part of the basic services. So you're going to be delayed while they find and make the copy. They'll send it to disks and ship it back to you. You'll have to restore it. If it's personally protected information, it may be going in unencrypted form out through the mails or UPS or FedEx, which is another form of exposure that you may not have planned for. And there are issues about the authenticity of the data and, of course, the cost, since these are all outside the normal range of contracting services. So these are some of the issues that are there. As I said, the tools are being developed. There are providers who have entire systems that will enable this and make it easier. And there are ways, using some of the models we showed earlier, to channel this and for a company to maintain control. But if a company allows cloud use to grow helter-skelter, it's not unlike a situation, if you go back to paper, where your employees are storing critical company documents in the trunk of their cars, in the garage at home, in desks, and no one knows where the paper is. Try to avoid that.
So let's talk a little bit about some of the terms that you might see, or how you would characterize generally the terms that cloud services are generally offered. One of the common aspects of cloud computing, and one of the differences from its predecessor, sort of outsourcing, more customized arrangements, has been the limited negotiability of the agreements that you find. And that's primarily because many of the cloud services are offered to the consumer directly or to subject matter experts. Generally, cloud services fall into a few different categories. Those that are offered to direct to the consumer or the subject matter expert, the SME, I would call like a computer programmer to develop an application or something like that. Those that are offered to small, medium-sized businesses, and those that are offered to large businesses or government entities. And on that spectrum, on the side with the consumer and SME, very limited negotiability. You will, however, if you're a very large commercial entity or a government agency that's going to be making large use of the cloud solution, be able to negotiate meaningful changes to the model. So I would caution you, if you're on that right side of the spectrum, from going out and trying to find sort of publicly available forms of cloud agreements, because they'll be quite similar when you come across them, and they will typically, if there won't be the most one-sided agreements you've seen, they'll be close. And that's really because the revenue model for most cloud providers is premised on a very low level of liability and low exposure, and a high volume of users and revenues. And for that reason, you see quick wrap models, modular forms are used even across the spectrum, really. And when I say modular, there's typically, I would say, 4 documents that you'll see when you come across a cloud arrangement. That is, the first being the terms of service, which describe the agreement between the user and the cloud provider. The next would be an SA form. You always see that, but a service level agreement, which will tell what level of service you can expect, the uptime, log data, and what you might get if the provider breaches any of those commitments. Actually, universally, the cloud providers will give you a form of remedy that is a credit against future service, and we'll get into some details on that in a second. The next form of document is called AUP, or an acceptable use policy. It's not always included in the terms of service, so you have to be careful. Sometimes it's only included by a link or a reference, and it's located elsewhere because it applies to a number of different products that the provider may. But it in essence governs your behavior while you're using the cloud product. So, for example, Facebook says that you won't. Acceptable use policy says you won't post harmful or offensive content, and it's actually several pages. But that's the type of information that's in the AUP. And then finally, there'll be a privacy policy of some sort. It may not always be called this, but it may be called data policy. But it will tell the user essentially how the cloud provider manages the data that's stored on the cloud. And so you have to take a look and track down all 4 of those documents to understand the full scope of what the services you're getting and the limitations that you're subject to. A concern, and this can be confusing as legislation evolves. Hopefully, it will become less confusing, although lately there's been more legislation, and it hasn't always been thoroughly vetted against what's currently out there. We don't have time to go into all of the privacy and security issues, but suffice it to say that just about every state now has laws that the use of consumer data and require the providers to do certain things, mainly provide notice, and certain states require certain affirmative actions to the extent that the provider unintentionally discloses or there's been a security breach of the consumer's data. Legislatures are focused on this because right now it's a patchwork, and typically North Carolina, surprisingly, and California, not surprisingly, have been the most restrictive in terms of they all will define what they mean by consumer data. The definitions are not universal, and then they will define security breach. And again, those definitions are not consistent across all 50 states. Last week, Rick Perry signed into law in Texas, which says that if you do not comply with Texas's laws, the Texas Attorney General, if you have any or any consumers within the state of Texas, will have jurisdiction, and they can fine you and penalize you and exclude you from doing business in Texas if you don't comply with data breach laws. So expect, as this being a political cycle for the next couple of years, that there'll be a lot more of these laws coming on the books. The next slide gets into a little bit more detail. These are some of the laws that regulate the privacy issues that the cloud providers should be handling data. Unfortunately, for the users of cloud services, it's not cloud providers so much that are responsible. It's the businesses that are taking the information from the consumers that are ultimately responsible. And what we see here is, in addition to that, as law different jurisdictions, as they evolve, they will collide. For example, the European Union has data security laws which are much more restrictive than those in the U.S. And so, in the U.S., it's okay for the government to subpoena a cloud provider and obtain customer information. And in fact, many of the terms of services that cloud providers offer point out to the user, and that's pretty much an accepted practice here. In the EU, it's very different. The citizen's personal information is personal. Absent very high level of government intervention, nobody can access that information. And so, last month, the Netherlands essentially barred U.S. providers. Well, actually, earlier this month, U.S. providers from doing business with the Dutch government because many Microsoft and Cisco were the ones that were really the subject of this bid, but they essentially have terms in their terms of which say that the U.S. government can subpoena the information of the cloud providers and obtain that information, and that's very much at odds with the European Directive. And so, as a result, they are no longer allowed to do business in the Netherlands. What's interesting is that so far no other European countries have followed suit in making such a bold statement, although their laws are very much the same and they're subject to the EU data security laws just as the Dutch government is. Another that users will find challenging when dealing with a cloud provider is business continuity. Here, and that's basically what happens when a cloud provider is out of service or loses data. The customer really needs to think about negotiating in business continuity practices that will allow quick access to information and also to get that data back. In the services that are out there, what we're seeing is sort of a variation between cloud providers saying that they will data for any from 3 days to 120 days after the service ends. After that, all data will be expunged. There's very limited offerings in terms of the services that they are going to provide to help get your data back. There's very little detail about where your data will be kept, so to Carl's point, so that you can go in and get the data down if you're not in a contract or on good terms with the provider. And the other end of the spectrum, we find terms which will say we may retain it, we may not. Your data is at risk once the customer relationship ends. And then some, like for instance, Apple's mobile service, MobileMe, will say that we will expunge data. You will have no access to data when the term of the contract ends. So diligence is going to be important in finding out what is going to happen to your data if there's some type of interruption in the service or the term ends. Amazon reacted to this by stating that you can opt for regional data action, which will not give you an exact location, but it will keep your data within a certain region of server farms within which you can go back and get the data out. Higher contracts will actually provide you, if you negotiate for them, a procedure to transition to an alternate cloud provider, or if there's an interruption of the service, to flip to some type of mirrored site somewhere else, or to engage a third party to continue the operations of your business. Another fast becoming hot topic in the industry is the issue of bankruptcy. And this is an issue because it's not so much that the cloud providers don't want to get that your data is an asset within the bankruptcy itself. It's just that the data itself is subject to the other assets of the debtor, and such, without actively funding the operations of the cloud provider, it will be impossible to get your data off. And your level of risk goes up depending on what model of cloud services you are subscribing to. So on the one hand, the infrastructure as a system presents typically the least complexities because you're only really using the hardware, and only the hardware is implicated. So there, your bankruptcy will impact sort of the direct provider, which is the entity that's managing the infrastructure. As you go up the chain with the platform as a system, there are not too many additional classes of participants because you're relying on the direct provider of the software and the network systems. But you will have, I guess, in addition to the hardware providers, you'll have network providers as well. Once you move to software as a service, the pool of risk expands because now you have the application developers, the software providers that license the key components to those applications, the structure host, and the networks that you had under the PaaS models and the IaaS models. So what that means is you are basically at mercy to get your data back, or at the mercy of the trustee. 362 of the bankruptcy code will validate the action and prevents action to obtain any of the property of the data of the debtor's estate, and that could impact their ability to go into the server farms or into the products itself that are remotely hosted and extract your data. It does provide, though, a sort of a breathing room to step back and assess the strategy that would be necessary to take that information off. It depends on the charter that's filed. We also are forecasting greater problems for users of the cloud. If it's a Chapter 7 bankruptcy, operations will cease, and so management of the debt estate then falls to the trustee. So as the cloud, you're going to have to deal directly with the trustee. You will have, in all cases, disruption of the service, if not termination of the service outright. Under 11, the court can require the trustee to operate the business if in the best interest of the state and it's consistent with an orderly transition. But in order to do that, while it may afford you some additional breathing room, you have to have resources to keep the lights on, to keep the employees going in, to maintain the cloud services, and it will again be limited in your remedy by what is the available pool of funds that can be used to continue the business. So while we haven't heard that much about bankruptcy now, we are anticipating that as competition increases, as the economy puts more pressure on cloud providers, this will become more of an issue, and so it's something that you're going to want to think about when you're engaging a provider. And a few other provisions to think about here that you'll find in cloud service agreements. We talked about service levels and transition services. The force majeure and limit liability. Typically, cloud providers will limit their liability both in terms of the amount of funds that they will be exposed to in a claim, as well as the types of damages. It's pretty standard to see in most outsourcing agreements that limitations of liability will cover cover sort of direct damages, punitive, and others will disclose. In a cloud situation, commonly you will see the cloud provider exclude direct damages as well. It's unclear now how courts are construing that. It may be unenforceable against public policy. It may be interpreted that direct damages are simply nothing more than damage for the lost data that you have, which that risk is also, those damages are excluded in most of the other language that's in the disclaimers. We're going to watch that unfold. Certainly in Europe, there have already been some rulings that have found that those disclaimers are not enforceable, and so the limits based upon time of the service and the amounts that you paid into the claim kick in. So you'll commonly see, in addition to disclaiming all their damages, they'll say, in no event will our exposure be greater than either the service level credits that you would be entitled to under the service levels, or 3 months, 6 months, 12 months of the fees that you paid for the service. And that's, in the interest of time, I'm not going to go through them in great detail, but there's a couple examples for you. The force majeure, you can see the squishy language. They're not liable for inadequate performance, beyond a party's reasonable control. Well, when you're talking about a cloud solution, it's very hard to, it's very easy to anticipate that clouders and cloud users would differ on what is beyond a party's reasonable control. For example, infrastructure concerns, communication issues, where does that fall? And so that language is subject to differing interpretation. Inadequate performance, does that language go beyond breach of the contract or the inability to provide the services in accordance with the SLAs? Do you not get your service level credits? Arguably, the answer is yes there. Do you have the right to terminate the contract there? Google doesn't give you that right. So the next one, in levels, when you're talking about service levels, downtime is probably the most manipulated term. Here, it means if there's more than a 5% user error rate. Well, that's not entirely helpful if there's a delay in the responses, or if the user is unable to obtain an error rate. Elsewhere in the language, Google will tell you that its records are the sole definitive record of what the user rates were. So here it's about limitations of liability. Now we get into some of the ethics rules here.
This is attuned principally for the lawyers in the audience. Ethics rules are rapidly catching up with changes because of technology, because of cloud provisions and social media and the like. The ABA has a set of proposed amendments to the rules on professional responsibility and ethics. The ABA Commission on Ethics 2020 has been working on these for some time. Their target is to present to the House of Delegates by May of next year, with the expectation that the proposals would then be voted on at the annual meeting of the ABA in August of next year. Many states have already made changes to their rules, either because the Supreme Courts of the states pushed them through, or because the body that deals with rules is not nearly as encumbered with the kind of structural rigidities that the ABA's commission has. You can look up the individual states that apply. When dealing with cloud resources, because where the provider is and where the data is moving may be invisible to the user, there could be a lot of different states that actually impact on this. There's no particular standard that is, say, a federal standard yet. That has not happened. However, the essence of all the approaches is pretty much the same. There's a responsibility for safeguarding the information that the attorneys involved, the lawyers, when they're advising clients, must understand the risks. And if an attorney does not have the necessary technical competence, many of the rules are explicit that the attorney has to go out and seek support so that the attorney does not misguide a client. And it's necessary to do due diligence on this. So this, to me, seems like common sense, but it has swept through. I remember in early stages of dealing with computer communication, Iowa's ethics board made it a specifically unethical to communicate with clients by email without permission from the client and use of encryption. We've moved beyond that. It's a little bit less difficult now. But that was an extreme state, largely driven because the people who were making the rules didn't understand what they're dealing with. If you understand better, there still may have been good rules. With respect to case law and the legislative landscape, there's been much that deals in any aspect of cloud computing. The closest is a number of cases that deal with either Fourth Amendment and civil process issues. So these are things like, does the subpoena go to the host, the provider, or does the subpoena have to go to the individual user? And that gets into sometimes intricacies of how the particular service, like a Facebook or whatever, is configured, whether the information that's available is out publicly available, because even Facebook has a private mail communication side, or whether it can be, for example, reviewed by automatic systems or individuals for advertising tuned to particular users' needs. We're dealing with things like the Shared Communications Act, which has some very special provisions with respect to communications. There's no meaningful case that we're aware of on e-discovery in a cloud context. I'd like to point out, though, that things like Coleman versus Morgan Stanley and UBS versus Warburg, if you look into what happened there and what drove the judges to issue adverse inference instructions during trial, a lot of it was that the party that was trying to find the information had lost track of where information was and would continually, through the course of the litigation, find more and more and more data. In each case, as you approached trial, in Morgan Stanley it was, I think, on the eve of trial, whole rooms of computer tapes would be discovered. And that put the judge completely out of sorts. If not managed and taken charge of the cloud services being used by an enterprise, the same kind of situation can be replicated. There's no case law that gives anything meaningful in the way of technical issues. As Jay described, there are tensions between the United States and the European Union about privacy, and the legislatures are all working on these issues as well. So the legislative landscape is in flux. There's not a lot of case law guidance, and one really needs to exercise good planning and try and take charge. This is a brief diligence checklist that's in the materials, and that, if there are any questions, we'd be happy to take them. All right. Very much, and please fill out your evaluation forms.